Not understanding this concept could result in a grievance. Hi, I'm attorney Jill Ruane. In today's class in 2-Minute Law School, we are talking about when an attorney has a conflict of interest. In legal ethics, a conflict of interest happens when a lawyer's ability to represent a client is compromised because of competing interests. This can involve the lawyer's own interests, the interests of another client, or obligations to a third party. Lawyers are expected to be completely loyal to their clients, and a conflict of interest can get in the way of that loyalty. There are different types of conflicts of interest. First, let's talk about a concurrent conflict of interest. It arises when a lawyer represents two clients at the same time and their interests conflict. This happens when representing one client will directly harm the interests of the other client. The lawyer's ability to fully represent one client is limited by their duty to the other client. Next, let's talk about a successive conflict of interest. A successive conflict of interest happens when a lawyer's duty to a former client could conflict with their duty to the new client. Lawyers have a duty to protect confidential information from former clients. So, if representing a new client would involve using or revealing that information, there's a conflict. Say a lawyer represented a client in a divorce case, and later that client's ex-spouse asks the lawyer to represent them in a new case. The lawyer might have a conflict because they could have confidential information from the first client. This would create a successive conflict of interest. And lastly, let's talk about a personal conflict of interest. Sometimes a lawyer's personal interests can create a conflict. This might happen if the lawyer has a financial interest in a case or a personal relationship with someone involved. If the lawyer's own interests could influence their ability to represent the client objectively, that's a conflict of interest. So, if a lawyer is asked to represent a business in a lawsuit and the lawyer owns shares in a competing company, their personal financial interest could interfere with their duty to that client, and that would be a personal conflict of interest. In some cases, even if there's a conflict of interest, a lawyer can still represent a client if the following conditions are met. The lawyer reasonably believes that they can still provide competent and diligent representation to each client. The conflict isn't prohibited by law, and all affected parties give informed written consent after being fully informed of the conflict and its risks. However, some conflicts are so serious that a lawyer cannot represent the client, even with consent. Like when both sides want to be represented by the same attorney, this is almost always prohibited. And that's it. We'll dive a little deeper into some of these topics in future classes. Class dismissed. But first, if you wish you went to law school or you just want to be smarter and win that next argument with your friends, be sure to hit that subscribe button and ring that bell so you can get new classes when they drop.